Councillor McKee, with your declaration of interest again. Thank you. Right, thank you very much. Okay, the first item for consideration today is West Cairngaan Stranraer Refusal of Planning Permission for erection of 2 wind turbines, 15.08 metres high to hub, 19.33 metres high to blade tip, 12P10174. You've got a number of documents in your papers, being the Notice of Review, dated 19th of November 2012, and related documents submitted by VG Energy, agent on behalf of Mr. William Burkett, the applicant. You have the report on handling. You've got observations of interested parties and the appointed officer on the applicant's notice of review. You've got the planning application form dated 1st of June 2012, plans and supporting documents. And you also have the decision notice from Dumfries and Galloway Council dated 28th of August 2012, and relevant extracts from key planning documents such as the Dumfries and Galloway Structure Plan, Wigtown Local Plan, Scottish Planning Policy, and Dumfries and Galloway Council Wind Energy Interim Planning Policy. Lastly, you also have photos of the application site and the locality. So to start at the beginning, the grounds of refusal on pages 144 to 145 of your document are: the development would result in significant adverse environmental effects on the visual amenity and landscape character of the peninsula, the Rhinns landscape character type, and the Rhinns Coast Regional Scenic Area, where the scale of the proposed turbine would significantly detract from the character of this landscape. As such, the proposal is contrary to the development plan as contained in Dumfries and Galloway Structure Plan Policies E2, E3, S21 and S22, Local Plan General Policy 42, the Interim Policy on Wind Energy Developments February 2012, and 2 National Policy contained in Scottish Planning Policy February 2010. And 2. The proposed turbines, by virtue of their location, scale and particular design, would give rise to unacceptable degree significant adverse cumulative visual impact when considered in combination with previous turbines which would be granted permission in this locality. If allowed, the proposed development, which occupies a prominent and elevated coastal position, would increase the prominence of the existing nearby clusters and lead to a significant adverse cumulative visual and landscape impact, particularly when viewed from the Mull of Galloway and its visitor attractions and the exit routes from them, and from the Mull of Galloway Lighthouse itself. It is considered that the aforementioned developments have effectively used up the landscape capacity that was originally potentially available for such developments in the area. The requested method of determination by the applicant on page 14 is on the basis of further written submissions and by the means of an inspection of the land which is subject of the review. The ground status in the notice of review on pages 17 to 45 are, in summary, that the applicant considers that the proposals would not have the degree of significant negative adverse impact and effect upon the landscape within the immediate area and greater regional character area as stated by the appointed officer. Most developments will have an impact and effect upon the landscape and local visual receptors. The agent states that the development has been proposed following guidelines set out by the Industry Standard, Landscape Institute and Institute of the Environmental Management and Assessment. and national and regional policies and guidelines regarding wind technology and siting. And 4, new material submitted includes a business case, page 21 to 22, for the turbines and additional photomontages and wire lines together with an assessment thereof. You have the further comments of interested parties, including comments of the Defence Infrastructure Organisation, comments of John and Jackie Paddiston, objectors, and comments of the appointed officer, Mr. Robert Duncan. As stated, you have the relevant development plan policies and any relevant material considerations. So the main issues for the local review body to consider are: do the proposals conform with the relevant development plan policies? Do the proposals conform with the Council's interim planning policy on wind energy and material consideration? If not, are there any material circumstances which would indicate that planning permission should be granted to the contrary? And are the LRB satisfied from the information provided that they are clear about the potential visual impact of the proposed turbines? So, having outlined the documents within the members' papers, it now falls to the LRB to determine whether it has sufficient information to consider the review. It is confirmed that there will be no representations from any party heard today. The LRB has the following options. It can decide it has sufficient information before it to enable it to determine the review today. It can request further information in the form of written representations. The LRB would have to state precisely the information it's seeking and who would provide it. It could resolve to hold a hearing, again specifying who will be invited to speak and on what matters. Resolve to hold a site visit, accompanied or unaccompanied, and this can be done in conjunction with any of the above, but would obviously not allow a decision to be made today. And if the local review body resolves that it has sufficient information and that no further procedure is required, then under section 43A.15, the local review body has the full powers to uphold, reverse or vary a determination, and section 43A.12a requires that the decision notice includes a statement of the terms in which the planning authority has decided the case reviewed. So an independent planning advisor is here at your meeting. He's here to assist. It is confirmed that he has not had any involvement in the case. It's not the case officer or the appointed officer. He's purely here to provide independent advice as needed on matters of planning policy, law and process of the local review body. So if members are clear and no further clarification is required, I will ask the Chairman now to lead the debate and for the LRB in the first instance to determine if they have sufficient information before them.
Thank you very much, Claire. I should have remind everyone present this meeting will be recorded and the recording will be subsequent. Councillor Geddes?
I would move so that we have sufficient information before us today to determine this application.
Thank you very much. Anybody otherwise minded? Okay, we'll take you through a section at a time. If you have anything to raise on that section, just give us a call. Item 1, the notice of review, dated 19th of November 2012, and related documents. Yeah, you want to, we've got slides. Do you want to go through them just now? You could, please.
Thank you, Chair. These are basically the same slides as you will see in your agenda papers on page 163 and 164. So the first view is looking southeast across the site from the U118 road. So the site is sitting in round about the middle of the slide here. And this one is looking southeast from the farm itself, looking across the site. Again, turbine sitting around about the centre of the slide. Next photo moves further up the road. If I'm correct, I think that's one of the turbines that has been implemented nearby. That's the farmhouse, and again, the turbines would be around about the centre of the slide. And the next shot is a zoomed in shot again. You can see how close the site is to the sea in the distance there. This is just to give you a flavour of where we are. The dot here will show you the farm is here. These are the two turbines which are before you today. The same farm had 3 turbines granted planning permission and 3 turbines also refused permission. The red dots are ones which are either permissions that have been refused or have been granted and since expired. The green dots, such as around there, are ones which have actually received a grant of planning permission. Thanks, Chair.
Section 2 also includes the letters of objection. Section 3, observations of the interested parties and the appointed officer on the applicant's notice of review. Planning application form, section 4, page 89 of 46. Section 5, decision letter from the council dated 28th of August 2012, page 141. Section 6, relevant extracts from the structure plan, Dumfries and Galloway structure plan, the Wigton local plan, cottage planning policy, and Dumfries and Galloway Council wind energy interim planning policy. Item 7 is just the photographs you've already seen on the screen. So we're open for debate. Councillor Geddes?
Well, I would have to say, sir, that, and I'm sure we all have been through these papers with the proverbial fine-tooth comb. And my view, Chairman, is that the case officer has got it correct. I think that the decision spelt out clearly on page 144, 145 of our papers, quite clear, the significant adverse environmental effects of on the visual amenity and landscape character of the peninsula, runs landscape character type, and the proposed turbines, by virtue of the location, scale, and particular design, would give rise to an unacceptable degree of significant adverse cumulative visual impact when considered in combination with previous turbines, etc. In my view, sir, I have no compunction whatsoever in supporting the case officer's findings, and I would move that this LRB uphold these and refuse the application.
Anyone else want to comment? We all in agreement with Councillor Geddes' views? Councillor Blake, quite happy with it? Councillor McCoughtry? Unanimous decision that we uphold the decision of the planning officer.
Thank you. Just to confirm that the local review body is upholding the decision of the appointed officer and refusing on the same grounds as laid out in the paper.
Thank you very much. We might now move to item 2, notice of review, refusal of planning permission for erection of 3 wind turbines 23 metres high to hub and 32.7 high to blade tip, Gleniron Farm, Glenluce. Planning reference number 12/P/1/0174. Please.
Thank you very much. As before, the local review body have the same key documents within your papers. The grounds for refusal are on pages 310 to 311, being that the development would result in significant adverse effects on the visual amenity and character of the upland fringe, Camry and shallow flat-bottom valley landscape character types, where the scale of the proposed turbines would overwhelm the scale and detract from the character of the landscape. As such, the proposal is contrary to Council Development Plan policy as contained in Dumfries and Galloway Structure Plan Policies A3, S21 and S22, the Interim Planning Policy on Wind Energy Developments, February 2012, and to National Policy contained in Scottish Planning Policy, February 2010. The proposed development would detrimentally impact on the appearance and setting of the Gleniron, Cambridge Cairns and Cairn, a scheduled ancient monument, and the appearance, setting and experience of designated archaeological sensitive area by virtue of the siting of the proposed turbines on a prominent ridge top, the motion of the turbine blades and their height. As such, the proposal is considered to be contrary to policies E12 and E13 of the Dumfries and Galloway Structure Plan and General Policies 54 and 55 of the Wigtown Local Plan, the Interim Planning Policy on Wind Energy Developments, February 2012, and to National Policy contained in Scottish Planning Policy, February 2010. The requested method of determination in this case is on the basis of written submissions and by means of an inspection of the land which is subject to the review. Grounds stated in the notice of review are, in summary, the applicant considers that the decision was unreasonable as the impacts have been deemed to be greater than shown in the environmental report and associated photomontages wire lines. 2. From a site visit and landscape and visual impact assessment, the applicant submits that although the development would be visible, the overall visual impact is anticipated to be moderately adverse. Most developments of this nature will have an impact upon the landscape, and as this has been considered as an issue, the applicant wishes this to be assessed in more detail. He also wishes the impacts on Gleniron, Cambridge Cairn and Cairns to be evaluated again with the aid of photomontages from this location. New material submitted includes a business case for the turbines and additional photomontages and wire lines together with an assessment thereof. We have further comments of interested parties, being the comments of Historic Scotland and the comments of the appointed officer, Mr. Robert Duncan. And as previous, you have all the development plan policies. So the main issue for the local review body to consider are: do the proposals conform with the relevant development plan policies? Do the proposals conform with the Council's interim planning policy on wind energy, a material consideration? If not, are there any material circumstances which would indicate planning permission should be granted to the contrary? Are the LRB satisfied with the information provided that they are clear about the potential visual impact of proposed turbines? And how much weight does the LRB wish to place on the objection from Historic Scotland regarding the impact on the appearance and setting on the scheduled ancient monument of Gleniron, Cambridge, Cairn and Cairns? So, having outlined the documents within the members' papers, again it falls to the LRB to determine if it has sufficient information to consider the review. It's again confirmed that there will be no representations from any party held today. So, and as before, the LRB has the same options that I've outlined for the previous item. So that being basically a site visit, hearing, or written submission. So that if the local review body resolves that it has sufficient information and that no further procedure is required, and under section 43A15, the local review body has the full powers to uphold, reverse or vary a determination, and section 43A12A requires that the decision notice includes a statement of the terms in which the planning authority has decided that the case be reviewed. So if members are clear, again, and that no further information is required, I'll again ask the chairman to lead the debate.
Thanks very much for that. Mr. Sucky, would you like to take us through the pictures, please?
Thank you, Chair. These are, again, the same case officer photos that you'll see on page 331. First one is taken from the public road looking north. So the site actually lies just beyond Dr. Park, lies in the area here beyond the trees. And that's a zoomed shot of the same. Over the page, this is looking northwest across the application site. Again, the turbines, 3 turbines would be centralised. And the final photograph is, again, a more distant shot, and I understand the cairns would be placed up on top of the location plan to give you bigger context. The 3 horizontal dots near the centre of this slide are the ones which you're looking at. The other red dots, 3 dots in a line, these were refused. You can see a number of star here, which are as yet undetermined, and across here there's the 18 70-metre high turbines of Cairngaan Wind Farm that was approved on appeal. The cairn and cairns, you've got the cairn and then the chambered cairns are sitting around here, so you can see the proximity to the turbines which are under consideration. Thank you, Chair. I don't have them in the presentation, but I do have them on the laptop, so I can put them on the screen if you wish. Okay.
gives us a good idea what the area will look like with the turbines in place. Right, can we make a start? Can we agree that we've got sufficient information in the papers before us? Continue. Thank you very much. Notice of review, starting on page 165 of 446. And then I can just call. Report on handling, right, section 2, page 193. Onwards. Okay. Section 3, observations of interested parties on the appointed officer on the applicant's notice of review, page 215 onwards. Section 4, planning application form, 227. Section 5, decision letter from Dumfries and Galloway Council dated 25th September 2012, page 307. Section 6, relevant extracts from Dumfries and Galloway structure plan, Wigton local plans, cottage planning policy, and Dumfries and Galloway Council wind energy interim planning policy. And section 7 is a photograph, similar, same as anybody want to raise any issues? I think the wireframe pictures show the actual effect on the countryside, given the area it's in, the number of wind turbines in the area. I would certainly an officer's decision. Councillor Geddes.
Well, I would certainly agree with you, sir. I think in this particular instance that the planning, not only the case officer, but also the area planning manager in his comments, you know, have got the situation right. I mean, I do appreciate, I'm sure we all do, Chairman, the importance of agriculture, particularly in the west of the region, and the desire of people involved in agriculture, as it were, you know, to diversify and take advantage of other income streams. But as Mr. Duncan says in page 223, paragraph 2.2, however, it should not override sound planning principles. It has to be accepted by landowners and developers that there is simply not the landscape capacity available for every farm unit or landholding in every landscape character type to have its own wind energy scheme or schemes of disproportionate size. And interestingly enough, as far as what's real interest to me, sir, if you go to the bottom of that page, paragraph 2.6, Mr. Duncan points out that officers have already given consideration to alternative solutions which may be able to meet the needs of the applicant in this regard on the same farm unit, and it is not considered that this proposal represents the only option open to the applicant. Can I remind you, sir, because I think you and I served in the same planning applications committee. Some time ago, we had an application for a single turbine just in the outskirts of the village of Whinniehill, and it came before the committee, and the committee took a decision, actually against the officer's recommendation, to refuse it. But at the same time, and it went to appeal, and the committee's decision was upheld, for the record. But having said that, when we took that decision, we made it abundantly clear to the applicant that, we felt that there were other more suitable locations. To be fair to the applicant, he accepted the steer that was given him. He went away, came back to the planning officer with a proposal, an alternative proposal in another part of his farm, and that was granted, Chairman, under delegated powers. Didn't even have to come before elected members for a determination. And I would hope that if there is the finding of this board today to uphold the case officer and the planning officer's recommendations, that the applicants who are here, I'm aware, will hear what's being said, will in fact work constructively with our planning staff, and hopefully we can get a solution which would be acceptable to them and also acceptable to the council. I'm not suggesting that can be part of the decision. I don't want to make it part of the decision, but as part of the background, I would like to think that these comments are helpful. But as I say, I'm with you, sir, on the basis of refusing the application on the grounds specified in the report.
Anybody else wish to comment? All in agreement? Thank you very much.
Thank you. I can confirm that the local review body is upholding the decision of the appointed officer to refuse the planning permission for the erection of the wind turbines at Gleniron Farm, Glenluce, on the grounds stated in the...
Right, thank you very much, Claire. I've declared an interest in this next application. We have somebody volunteer to be chair. Well done, I like that.
I would prefer to decline if at all possible.
A volunteer's better than 10 pressed men.
No, but I'm not volunteering, Chairman. Okay, well, let me make it clear, sir, I'm a pressed man, not a volunteer. Claire, would you like to take us through this particular application, please?
Thank you very much, Chairman. Okay, we're on item 6, the land between Whinniehill Cottage and Pearly Cottage, Lochfoot, Dumfries. Refusal of application for planning permission in principle for the erection of a dwelling house and garage, installation of septic tank and soakaway system, 12P 20209. Again, the members will have the same key documents in their packs. The grounds for refusal for this review are on page 410, one being that the application fails to demonstrate that a new dwelling house is essential at this location for the needs of agricultural or any other use requiring an appropriate rural location, and would therefore represent sporadic and unjustified housing development in the countryside. The proposal is therefore considered to be contrary to the requirements of Dumfries and Galloway Structure Plan Policy D4 and Statutory Local Plan General Policy 15. Requested method for determination is on page 342, and the applicant has requested that the review be dealt with on the basis of one or more hearing sessions. The grounds stated in the notice of review are, in summary, that they consider that not enough weight has been given to a letter from the former Scottish Government Chief Planner in a letter to Heads of Planning dated 4th of November 2011, or the Local Development Plan Main Issues Report, with grounds for refusal being based on the current development plan policies. They consider that the case officer was prejudiced, having previously refused a previous application. You also have further comments of interested parties, being comments of appointed officer, Mr. Robert Duncan, the area planning manager, Again, you have the relevant development plan policies being Dumfries and Galloway Structure Plan and D4 Housing in the Countryside, plus the Statutory Local Plan, General Policies 1, 2, 7, 15 and 60. You also have Scottish Planning Policy and Dumfries and Galloway Supplementary Guidance 3.3 Small Building Groups Statutory. So the main issues for the local review body to consider are: does the proposal conform with the relevant development plan policies, and critically, in the terms of structure plan policy D4, 3 and 5, has it been satisfactorily demonstrated that either site falls within a recognised small building group identified for further housing, or is there an essential and not merely desirable need for a house to be sited on that specific location for the purposes of agriculture? And B, are there any material circumstances which would indicate that planning permission should be granted as an exception to the policy? And C, what weight, if any, do the LRB wish to give to comments made by the applicant's agent regarding the letter from the former Scottish Government Chief Planner in a letter to Heads of Planning dated 4th of November 2011? A copy of this letter has been circulated. And also the age of the current development plan against the status of the proposed local development plan. What weight, if any, do the LRB wish to give to comments made by the applicant's agent regarding the case officer being allegedly prejudiced against the application due to his involvement in a previous refusal for the proposal? So, having outlined the documents within members' papers, it again falls to the LRB to consider whether it has sufficient information to consider the review. It is again confirmed that there will be no representations held from any parties today. So as before, the local review body has the same options available. It can decide it has sufficient information to enable it to determine the review, request further information in the form of written representations, resolve to hold a hearing, resolve to hold a site visit, or if the local review body resolves that it has sufficient information and that no further procedure is required, then under section 43A.15, the local review body has the full powers to uphold, reverse or vary a determination, and section 43A.12a requires that the decision notice includes a statement of the terms on which the planning authority has decided the case reviewed. Again, you've got the independent planning advisor here present to assist you. He has not had any involvement in the case. He is here purely to provide independent advice as needed on matters of planning policy, law and process to the local review bodies. So if members are clear and no further clarification is required, I will ask the chairman now to lead the debate and for the LRB in the first instance to determine if they have sufficient information before them.
Well, colleagues, I think that is, if we deal with the preliminary point, first of all, you'll see that the applicant's agents are asking for a hearing session. Would you be prepared to grant that application, or do you feel that we have sufficient information before us today to determine the application?
I feel there's sufficient information available to us just now to make a decision.
I would agree with that. So we're proceeding to determine the application today, and that particular motion, for want of a better term, is refused. Thank you. First section, colleagues, runs from pages 337 to 368, and that's the notice of review and related documents submitted by Messrs GM Thompson and Company, who are the agents on behalf of the applicant. Anyone have any comments or observations or points they wish to raise for clarification in that section? I take it that the silence signifies, colleagues, that no one has any issues they want to raise. So the second section is the report on the handling, which is determined under delegated powers, as they all have been, and related consultee and representative comments. And you'll see that these run from pages 369 to 384 of the papers. Anyone get any issues or comments or points they wish to raise in relation to that section? 369 to 384. No comments or observations, colleagues? Okay. The third section then set out in the papers. That's the observations of the interested parties and the appointed officer on the applicant's notice of review. That's page 387. Any comments or observations to be made in this? Yes, Councillor McCoughtry?
Just the one. You know, it refers to the letter from the Chief Planning Officer. And are they attempt to change policy here by saying that they no longer wish to see us putting in occupancy restrictions vis-a-vis Section 75? Is that what they're referring to here?
Mr. Sutty?
Thank you, Chair. This is actually something I do know quite a bit about, because I was actually involved in the working group that was behind this. It came from one specific issue that a minister was concerned that in his constituency was alleged that people were finding it difficult to get mortgages for houses which had planning permission and were subject to Section 75 legal agreements or occupancy conditions. So he asked the former Chief Planner, Jim McKinnon, to set up a group to look into that. It was very much on that issue, looking at the occupancy restrictions and the ability to get funding. The working group included representatives from various bodies, including councils, and also the mortgage lenders. And the view held there, of the unanimous view at the end of all these various meetings, was that there really wasn't the problem that was thought to be. So it was slightly at odds to the working group that this letter came out. There was concern that it was, and there was another two examples of this being policy by letter. It was not something which was subject to any consultation. And as I say, it was actually at odds to the findings of the group. Questions were put to, for example, the reporters unit, how would they view this letter? And they gave a clear view that it was only a material consideration. And if you look at the second last paragraph, it does make it clear that it states that development plans should support more opportunities. Basically, it is not saying that this overrides sound established planning policy. Basically, when you come to review your development plan, you should consider the issue of this. But it is not something for development management considerations. This has been tested at appeal, and including, I would add, in Dumfries and Galloway, and the reporter actually dismissed an appeal and basically made the same sort of comment that this is merely a material consideration. It does not turn established planning policy on its head. But happy to answer any other queries that members might have about that.
Wish to come back, Councillor McCoffrey?
I'm happy for that
I thought you might.
clarification because it works both ways. If they're saying this letter from the planning officer makes it clear that you shouldn't tie any restriction in, then I would argue the other way, that having been involved in it in the past, we always put section 75s on in cases where we would never ever have granted planning permission in any case. And I would say if this is what the Chief Planning Officer is now saying, then it's clear cut. You just don't grant planning permission at all. You know, I think if they're trying to make out this should make it easier to get a house in the countryside without putting any restrictions on, my argument would be the exact opposite. They just don't get planning permission.
Well, I'm grateful to you, Councillor McCoffrey, for raising the point, but, you know, and paragraph 1 of page 387, you know, it's quite clear that that's being said by the area planning manager, Mr Duncan, that the comments of the former Scottish Government Chief Planning Officer do not override established development plan policy, and he refers us back paragraph 4.4 on the report of handling, which is at page 373. And again, colleagues, I would suggest that as far as I'm concerned, that's compellingly clear that despite the averments to the contrary by the applicant's agents, that you know, Mr McKinnon's letter does not, in fact, override established development plan policy. Going on to paragraph 2 there, and the issue of prejudice on the part of the case officer, I would have to say that, in my view, that's an unfortunate use of a word which can have potential pejorative consequences. I'm sure that the applicant's agents did not intend that to be the case, but I would direct your attention, colleagues, to the latter part of that paragraph. If an application was considered to be contrary to policy and was refused, any identical resubmission should be considered in the same manner unless there has been a material change of certain circumstances in the interim, which is not the case in this instance. This is not a case of prejudice, but instead demonstrates consistency of decision making. And I would certainly agree with that, and I hope you would as well. Thank you. The next section, colleagues, is section 4, which runs from pages 389 to 392. Anyone, any comments or observations or questions to put in this connection? Councillor Thompson, my apologies.
Thank you, Chair. Just could I seek clarification on the last paragraph, where it stated that no comment has been made to our argument within our statement of case regarding the Dumfries and Galloway local development plan main issues. I'm not quite sure what's being referred to there, sir.
Thank you, Councillor Thompson. Mr Sutty?
Basically, my reading of this is that the applicant's agent was referring to the age of the existing development plan and was alluding to the fact that the main issues statement should be seen as a more up-to-date statement. The difficulty with that is that section 25 of the Planning Act, if you look at page 373, paragraph 4.1, which is part of the case officer's report, that gives you the clear definition of what section 25 of the Act is about. Basically, it's saying, in layman's terms, that when you're determining a planning application, you should consider first and foremost the development plan, unless there are material considerations to the contrary. So clearly, this application should be considered in respect of Structure Plan Policy D4, first and foremost, and only in the circumstance that there's some other reason for you to override that should a planning authority consider otherwise. The status of, for the main issues report was a very, very broad brush statement setting out the Council's rough intentions of going forward with the local development plan. As you'll be aware, we're currently in the consultation period in the Council for the local development plan where people can make representations until March. Accordingly, it has very, very limited weight at the moment. Even as the proposed LDP, it will gain more weight as it goes through the various processes and goes back to full council, then goes on. But really, the key thing is the existing development plan is what you should be considering an application against just now, unless there's a very good reason.
Thank you, Mr. Sutty. Do you wish to come back, Councillor Thompson? Okay, thanks very much, sir. Thank you. The next section is section 5, planning application form dated 12th of July, plans and supporting documents, which run from pages 393 to 406 of the papers. Colleagues, anyone get any comments or observations or issues to raise in relation to these? No comments, Councillor McCauley? Okay then, can we proceed to section 6, which runs from, that's the details of the decision notice, dated 18th of September 2012, pages 407 to 412 of your papers. Again, any comments or questions or points to raise in relation to these pages? I take it no one has any comments or observations to make. Can we proceed then to section 7 of the report, which are the relevant extracts from the structure plan, the statutory local plan, Scottish planning policy, together with a copy of supplementary planning guidance 3.3, which is small buildings group in relation to statutory. And that runs, colleagues, from pages 413 to page 440 of your papers. Again, if anyone has any comments, observations or questions to raise, can we have them from you, please? Councillor McCauley.
Just in line with what we've been going through, if you go to page 423, unsuitable small building groups, and the final one there is Whinniehill, Cottages, Lochfoot. So it ties in with the recommendation of the officer earlier on.
Thank you. You don't wish to make any comment in that regard, Mr. Suffy?
Other than the fact, just to note that it's spelt slightly differently, but I would assume it is the same property.
Thank you. Well, if there are no other comments, can we go to section 8 then, please, which is photographs of the application site and the locality, which run from pages 441 to 445 of your papers. Would you like to take us through these, Mr. Sutty, please?
Thank you, Chair. Again, these are the case officer's photos. You will see starting on page 443. This is looking southwest along the C1 public road, and that's Whinniehill Cottage that you're seeing in the foreground there. The site is behind the hedge. And then this is, you're seeing here is Pearly cottage, location here. You're just seeing the edge of Whinniehill cottage, so the site is behind the hedge, lying in there. And this is looking within the site, and you're looking southwest towards Whinniehill cottage. Next photo is just actually a zoomed up version of the same thing, a little bit closer. And then looking across the site. To give you a context of where we are, there's two location plans I've got here, so you can see you've got two larger farm units here. The small building group that was regarded as not being suitable is really 1, 2, 3, 4 properties with this land in between. And to show it in its context, you've got the A75 runs along the green one at the top here. And then you've got Lochfoot itself, and this is the road running past. So I think you can see quite clearly in terms of the scale of the development, it's not comparable to Lochfoot or any of the other larger settlements nearby. Which is, I assume, why it was decided it was a small building group, but not one suitable for further expansion.
Thank you, Mr. Sutty. No clarification required on the plans, etc. Okay. Well, can we? We're now very much in session. Can I have your comments, Councillor Thompson?
I think in the delegated report, it's put very succinctly on page 373, that policy D4, where none of the criteria is met and that the application should be refused.
I may say that I agree entirely with you, Councillor Thompson. Colleagues, anyone otherwise minded? No? So the decision then is to uphold the findings of the case officer and to reaffirm refusal on the grounds stated, i.e. that the application fails to demonstrate that a new dwelling house is essential at this location for the needs of agricultural or any other use requiring an appropriate rural location, and would therefore represent sporadic and unjustified housing development in the countryside. The proposal is therefore considered to be contrary to the requirements of the Dumfries and Galloway Structured Plan Policy D4 and Stewardship Local Plan General Policy 15. That's the decision, Claire, of the LRB. Well, I have no further business, colleagues, so I thank you all for your attendance and your input